from a foreign judgment creditor. So let's talk about how it works, because unlike a lot of the law that some of our offshore friends are used to, the Uniform Foreign Money Judgments Recognition Act is a state, these are state laws, these are not federal laws. So this is going to vary state by state in the US. And we're going to focus on New York, just because we had to pick a state to focus on, but understand that it really does matter where the assets lie, because while a federal court may or may not have jurisdiction, subject matter jurisdiction, it's state court law that's going to apply. So as some of you know, in the US, when you have an area where different states have different laws, there's oftentimes a uniform act. And in this case, in 1962, a lot of states signed on to this Uniform Foreign Money Judgments Recognition Act. It essentially codified common law rules that existed in a hodgepodge across the various 50 states. And it was meant to address concerns that non-US judgments wouldn't be recognized by a US court. And a majority of states have passed it. We're going to talk about the ones who have not and how to deal with those states. And then in 2005, so not that long ago, it was actually updated, and there were a lot of significant changes regarding burden of proof and statute of limitations. So statute of limitations, when can you do it? When do you have to act? You have a lot of time. There's two essentially, you have to live with the earlier of either when the judgment would essentially expire in the foreign country. So for example, in the US, some states will issue an execution on a judgment, but it's only good for a year. You have to live with whatever the foreign judgment is valid for. If it's only valid for a year, you have a year. If it's valid for 20 years, you have 20 years. Or you get 15 years from the date the judgment was rendered in the foreign country. So you've got some time. Assuming the foreign country's timelines are longer or don't exist, then you basically have 15 years to enforce it in the US. And the burden of proof is pretty straightforward. Initially, shockingly, it's on the party seeking recognition of the foreign judgment. But once that party establishes it's within the scope of the act, and we're going to talk about what that means, then the burden shifts to the other side, the other party, the party trying to avoid the judgment, to prove that one of the discretionary mandatory grounds for non-recognition exists. So step one, we're going to talk about obtaining the foreign judgment. You have to go obtain it. You're going to do that in your jurisdiction, whether it's the UK, whether it's BVI, Cayman, any offshore jurisdiction. We'll talk a little bit about 1782 in a minute, but once you have your foreign judgment, you have to file an action in a US court, typically in a state court, and we'll talk about what that suit looks like. And then you have to identify whether the foreign judgment is going to be enforced in the US state court, and that's where to initiate and how you do that. So step one, file an action in the foreign jurisdiction in accordance with their laws and procedures. So I'm not going to tell you, nor would I ever, how to get your foreign judgment, but you have to have a valid foreign judgment before you start this process. So you've presumably either gone through a trial, gone through some tribunal process, gotten to the point where you have a judgment, and now you want to bring it to the US to enforce it. I'm going to skip through the 1782 slides for a minute, other than to say, if you don't know it, Section 1782 in the United States is a federal statute that gives foreign litigants significant discovery rights in the US. You can file a 1782 petition in the US, and you can get discovery in the United States in aid of a foreign proceeding. And one way it can be used, and if we have time we can talk about that later, is if you have a foreign judgment, you might be able to get some asset discovery through 1782 if you have a judgment already. But let's focus right now on just trying to get the foreign judgment recognized. So first of all, where should you file it? We talk a lot about New York, and there's a reason for that. If assets are going to come through the US, a lot of times they're coming through New York. But that's not always the case. Somebody might have assets here in Miami. Somebody might have a fund set up in San Francisco. Somebody might have real assets in Chicago or Boston or Minneapolis. So you have to think and find out, where are the assets? That's where I want to file. And you want to file the case in the state where the assets are located. Because the other thing a lot of foreigners don't understand about the United States is, if you have a New York State judgment, you can't just take that New York State judgment to Florida and enforce it. You have to get a Florida court to issue its own execution in order to do that. So if you know the assets are in Florida, it doesn't make sense to go to New York, get the foreign judgment recognized, then take the New York judgment to Florida and start all over again. what you're going to do is start in Florida and get a Florida judgment. So New York's a prime example, and even the courts have recognized that it's a traditional forum and a generous forum to enforce foreign money judgments. And one of the reasons for that is simply that if you don't know where the money is, or if you think that assets are going to come into the U.S., chances are they're going to touch a clearing bank in New York. And therefore, you could have your judgment ready to go, and you can seize those assets when they come through New York. And New York has a pretty straightforward system for filing these actions. There's two ways to do it. One way is simply to file an action, what they call through summary judgment, or through initiation of a new state court action. Either way, the concept is you file a lawsuit in a New York state court attaching the foreign judgment and saying you want the court to recognize it. And the foreign judgment will be recognized and enforced in New York if it's final and conclusive and enforceable in the country in which it was rendered. Now, if it's being appealed in the foreign jurisdiction, many times the New York court will stay the proceedings to find out the result of the appeal. And that's this issue about conclusiveness. It's got to be a final judgment. You can't get a preliminary judgment that's on appeal and then run to New York. Chances are that's not going to be enforced. But this is what I was talking about earlier. You don't have to have personal jurisdiction in New York in order to enforce these judgments. New York and other states still exercise in rem jurisdiction. So if I am a Saudi prince and I have assets, or I have assets in New York, and a judgment has entered, and say in the Cayman Islands against me, that Cayman Islands judgment can be brought to New York and enforced against the Saudi prince who has absolutely no nexus to the United States other than he may have a bank account, or she may have a bank account. So understand, it doesn't matter where the person is, it matters where the assets lie. And the bigger part of this, which we talked about, is you can even file it if you anticipate that somebody is going to have assets in the state. So it can be a very useful way to gain leverage over the other side if you say, well, I've got my judgment from the foreign jurisdiction, I've enforced it in New York, and now if you have any assets that touch the state of New York, I can grab them. That's a pretty powerful tool to have given the dollar's role in the global currency, in the global financial system. But not all foreign judgments will be recognized as conclusive. So here's where things come in. If the judgment was rendered under a system which does not provide impartial tribunals, it's not going to be recognized. If it's from a system that isn't procedurally compatible with the U.S. requirement of due process, it's not going to be enforceable. Now, this is narrowly construed, but you can sort of guess some of the countries that maybe have due process problems, or the ones where the U.S. is more likely to enforce. And we've made a little bit of a list to give you an example. These countries are all, there were cases litigated about all these countries, and courts have either found that these countries don't comply with U.S. due process standards or do. And not surprisingly, most of the jurisdictions everybody in this room practices in or from will be recognized. Most of the Commonwealth jurisdictions, including the UK, the Cayman Islands, Singapore, Hong Kong, and the rest, most of the EU. On the other hand, if you've got a Liberian judgment, you might be in trouble. Don't try to enforce your Ecuadorian or Iranian or Nicaraguan judgment in New York, and certainly not from Cuba, North Korea, Iraq, or Congo. This is not an exhaustive list, but for the most part, there are cases that deal with this. But you get the gist of it, right? If you've got a functioning legal system in a country that provides due process, it will probably be enforced. If you don't, it probably will not. There's a lot of words on this slide, but here's the deal. So now you've found yourself with a jurisdiction that theoretically meets due process standards. What else do you need? Well, if I'm trying to defend, if I'm trying to oppose the enforcement of a judgment, there's a few arguments I can make. One of them is, did the foreign court have personal jurisdiction? And it's an important distinction because we've seen in many cases a foreign court will assert jurisdiction over a person who really had no connection to that forum or fora, and then take that judgment to the United States. And the U.S. court will take a fresh look, especially if there was no defense of the merits. We'll take a look to see if there was jurisdiction. One of the issues is whether the defendant was personally served in the foreign country. if you have a company or an individual who was physically served in that foreign country, chances are there's going to be personal jurisdiction. If you voluntarily appeared in the proceedings. So this is an important distinction before you ever have a judgment. If you're representing a client or you have colleagues who have been sued in a foreign jurisdiction and their assets are in the US, you have to think long and hard whether you want to appear. Because once you appear in the foreign proceeding and you defend yourself on the merits, you've lost the right to claim to the US court that there's no jurisdiction. At that point, you have voluntarily submitted. So in some cases, there is a strategic decision to be made whether the individual that's been sued should simply default and then let the plaintiff bring the case to the United States and try to enforce it. Because there you can make a personal jurisdiction argument that might be more receptive in a New York or US court than in the foreign jurisdiction. If you're domiciled in the foreign state, a New York court or any court is going to recognize it. That means companies that are incorporated in that jurisdiction. If you're a BVI registered LLC and you have a judgment entered against you by a BVI court, it's going to be recognized. You're not going to be able to argue, well, it was just a shell company. You know, I never knew I could be sued. Same thing with individuals. If you're domiciled in a foreign state, you're going to be subject to jurisdiction. Same thing with a business office. If you have a business office in the state and that business office is the subject of the proceeding, you're going to have to live with the application of jurisdiction. The last one we almost never deal with in a group like this, but if you're operating a motor vehicle or an airplane and you commit some tortious act, you're going to be subject to jurisdiction. So if you get in a car accident in Cayman and you're sued in Cayman even though you're a US citizen, you're going to be subject to jurisdiction of the Cayman courts, and that will be enforced in the US. Now, even if all of the above are met, this is why I love US law. It keeps us lawyers busy all the time. There's a catch-all. If there was the court can find that personal jurisdiction existed if there were sufficient contacts between the defendant and the foreign country. I don't know what that means. I wish I could tell you what that means. It's sort of based on this concept in US law of overall contacts, right? And this is the old, if it smells right, it probably is right test. But you have to be careful because even if you can't check all the other boxes, a court could still exercise jurisdiction. Now, if you're on the other side of this coin and you want to avoid a foreign judgment or you want to have one recognized, what are the grounds? Is there discretion? And the answer is yes. So a US court in its own discretion doesn't have to recognize a foreign judgment if the court didn't have jurisdiction of the subject matter. So remember, we were talking about personal jurisdiction a minute ago. Now we're talking about subject matter jurisdiction. If there was no subject matter jurisdiction, a US court could refuse to enforce it. And also, if the defendant in the foreign proceedings did not receive notice in time to defend himself or herself. This happens a lot, right? There's service that allegedly is made. The person has no idea they're being sued in Singapore. Judgment enters. And even if the court did have jurisdiction over the individual, a US court might find that you never received proper notice, you didn't know about it, and might refuse to enforce it. So if you're trying to enforce a judgment, it's a good idea to make sure the person you're suing in the foreign country actually knows about the litigation. If the judgment was obtained by fraud? This comes up a decent amount, especially in some of the more dodgy jurisdictions. If the underlying judgment was procured by fraud, it's unlikely that a US court is going to enforce it. Another one, the judgment is based upon an issue that's repugnant to public policy in the US. You can sort of think that through, but there are certain, you can get into them if you want to, defamation claims. There are certain claims that are just so anathema to the values of what you'd think of as in the US that a court's just not going to enforce it. Those are rare instances, but they do happen. And we see them particularly in sort of the free speech type of environment where you have defamation and other types of claims. The proceedings in the foreign court were contrary to an agreement between the parties under which the dispute should have been settled. If you have a contract dispute and there was an arbitration provision or there was a private mediation provision, the US court's going to look at that. And another lovely catch-all, which I love, the foreign court was a seriously inconvenient forum for trial. when jurisdiction was based only on personal service. So you have a matter that is filed in Hong Kong. The person is served physically, either in Hong Kong or say in London. Yes, they got personal service. They might have been visiting for that moment. But if you're talking about a US citizen who was on Hong Kong for holiday or for one business meeting that was unrelated to the suit, yes, they were served in the foreign country, but a US court could rule that that was just a seriously inconvenient forum and therefore we're not going to enforce it. So something to think long and hard and seriously about when deciding, do I defend the action, do I not defend the action? How can this judgment be enforced later? This is our defamation issue we were talking about. This gets very complicated. If you're dealing with a judgment that's based on defamation, you need to look long and hard at it to figure out whether a court here in the US will enforce it. And there's also a big question mark about some intellectual property cases because the First Amendment concerns can sometimes act as a bar to enforcement because, again, if you did enforce that judgment, is it contrary to US public policy? So I'd say for most of you, the thing when we talk about this issue here is if you have an intellectual property judgment, take a close look at it. You want to make sure that a US court would enforce it and not say that enforcement would be repugnant to our public policy or so contrary to the First Amendment, even though the First Amendment might not apply in the foreign jurisdiction that we're not going to enforce. Okay, what happens in a state where the Foreign Judgment Act has not been adopted? So we're going back to sort of English Commonwealth law here now. The states that have adopted the act, for the most part, are the ones you'd expect: New York, California, Delaware, Florida, Texas. But there are lots of states that have not. You can see the list here. I won't read it, but some of these actually matter. Puerto Rico is kind of an interesting one because for many of my Caribbean colleagues, the person against whom they have the judgment might have assets in Puerto Rico. But some of these cases, some of these states have significant business interests. Tennessee is a good example, right? There's a lot going on in Tennessee these days. Arizona, there's a lot that goes on in Arizona that there are assets. It might be real estate. There might be financial instruments that you cannot use the act to seize. And so how do you do it? The way you do it is you have to file a separate common law claim in those jurisdictions. And this is sort of an interesting little issue because every state is going to be different, and you have to know where the assets are and what the state requires. For example, in some of these states, like in Tennessee, you have to go file essentially a lawsuit claiming collection on a debt. The Tennessee courts would consider the foreign judgment to be a debt. The problem with some of these common law jurisdictions that haven't adopted the act is all those protections that were in the Uniform Act do not necessarily apply. The courts will likely take a look if there was some egregious violation, like it was obtained by fraud or there was no jurisdiction in the first place. But as a practical matter, if you're in a state that has adopted the act, then you need to think long and hard about, if it's not adopted the act, you have to think about how you want to approach it. And again, it all starts with where are the assets and how can I seize those assets? If the assets are in New York, you're fine. If the assets are in Louisiana, you might have a problem and you need to think about it. So I want to give people a sense of timing too, because this process, especially in New York, can move relatively quickly. And I've seen some surprise in that front from people who are having a judgment enforced against them. We talked about New York a little bit when we talked about the summary judgment proceedings, the summary initiation proceedings. You can go from filing an action in New York to getting a final judgment within a few months. It's not a years-long litigation process. It generally goes relatively quickly, and unless the other side has something significant to put up in terms of a defense, it's fraudulent, it's from Liberia, they didn't have personal jurisdiction over me, I didn't even defend on the merits, it's likely going to enter. So if you think about a typical case, and I've handled many of these, where you might have a UK court, handles a matter, defendant is present, defends on the merits, and simply loses. When you bring that UK judgment to New York, it's going to be enforced within a few months at worst, and there's going to be an execution that's going to issue, and then you can start to seize assets in the state. So we're not talking about a process that is going to last years, typically. Lastly, I want to go back and refocus on one little piece, and that is this jurisdictional issue. And I want to explain it because it is the most important strategic decision you will make in that foreign court. And that is whether you submit to the jurisdiction of the foreign court in the first place. And this is one where there's no right and wrong answers. It's the application of strategic judgment. But if you decide to actually show up in the foreign court, you can challenge jurisdiction as long as that's all you're doing. And that's another thing you've got to confront, right? Just because you have to apply the U.S. notion of only contesting jurisdiction with whatever the foreign court does. Bottom line, whatever you do in that foreign court, you do not want to take any action that would be seen as a defense on the merits. So you want to say the court doesn't have jurisdiction over me, not the court doesn't have jurisdiction over me and this whole thing is ridiculous and it's false and it's wrong and it's a fraud and you should dismiss it. Just jurisdiction. But then you need to make that choice, right? Do I defend on the merits in, in Thailand, in Singapore, in BVI? Because once you do, you are probably going to get stuck with that judgment. And you have to decide, is it less of a risk that I let the judgment enter and fight the jurisdictional piece in the U.S.? The flip side of that is, once you let the judgment enter, once you let the foreign court enter a default, you cannot challenge the merits decision in the U.S. anymore. You can only challenge jurisdiction. You can't come to the U.S. and say, okay, now I want to fight the case on the merits. It doesn't work that way. So you've lost the ability. Once a court in the U.S. has decided under the Act, the foreign court had personal jurisdiction over you and all the other pieces were satisfied, you don't then get to say, okay, now I want to defend on the merits. You've lost that right. So that's a really important decision that has to be made at the very beginning of a case. And my experience has been a lot of foreign practitioners, foreign lawyers don't think about that. They don't know about that. They just handle the case the way they would typically handle it in their foreign jurisdiction. And if there are assets in the U.S. and you think that there's a chance that a judgment will ultimately come to the U.S., then you need to go ahead and think these issues through and talk to a U.S. lawyer. So we talked, that's the enforcement of judgments here, and that's sort of the good, if you want to enforce a judgment, the good of the U.S. legal system. In a minute, we're going to talk about the bad and the ugly. And let me put it in perspective. The U.S., as many of you know, on the regulatory and the criminal side, will assert jurisdiction over people from all over the world. And that's the flip side of this, right? We'll accept jurisdiction when you want it and you need it, but we'll also come after you when you probably don't want it and don't need it. So I'm going to turn it over to my partner, Rob Fisher, to talk about how U.S. laws can reach you. And feel free to be interactive, but we are going to leave time for questions as well.
Thank you, John. Hello, everyone. Yeah, feel free if you have a question, just interrupt me. I was a last-minute recent addition to this, so my PowerPoint is not as sophisticated, robust, yeah, as John. So feel free to just raise your hand and ask a question. Again, my name is Rob Fisher. I was a longtime prosecutor, federal prosecutor. Then I worked for FINRA. I'll talk a bit about FINRA, which is the Financial Industry Regulatory Authority here in the U.S., and I'll explain what their role is and the limits to their role. But of course, I want to expand upon what John said. The immense role the U.S. does play in enforcing its laws in other countries and against foreigners. For instance, now that I'm at Nixon Peabody, I've been doing a lot of FCPA work, the Foreign Corrupt Practice Act. That it's a robust U.S. law that is used by many different agencies. The DOJ, the SEC will use it. In fact, in the limited time I've been at Nixon Peabody, just about 2 years, that's been a significant piece of my work. And I've traveled internationally quite a bit to conduct internal investigations for companies that are under investigation by the SEC or the DOJ. And a lot of people wonder, including my wife, you're spending a lot of time abroad interviewing people that are not U.S. citizens, what is the role the U.S. government is playing in that? And essentially, the U.S. government sees itself as, in a way, the world's policeman for corruption. So any U.S. company or any foreign company that has U.S. agents can be under investigation if they're a public company by the SEC, or if they touch public companies, or by the Department of Justice. And that really allows them to stick the tentacles of the U.S. out around the world, so that lawyers like myself find ourselves in Germany and China and the Middle East or Africa, a new matter in Africa now, interviewing employees of companies, asking them about potential corruption that affects the company. Oftentimes what it is a bribe paid for a foreign tender or contract with the government, or a bribe to a potential customer that involves a public official. Case in point, of the past year and a half, I was working a very large SEC investigation against a U.S. public company, myself and an associate here, Mark Calderon, who's in the audience. And we did a huge investigation for this company in Germany, China. We did a self-report for the China piece of the investigation. And we got a good result for the company, but the amount of work and the expense that companies will expend to defend an FCPA investigation and this is by the SEC, not even DOJ, can be immense. And it is very important, and I tell all my clients this, the moment somebody gets a subpoena from a U.S. governmental agency, you have to make sure you reach out to an attorney who is sophisticated enough and knows how to handle that subpoena, but also interact with those agencies. So case in point, I think it's public this morning, that company we represent, who went through this giant FCPA investigation. They had had one previously with the SEC back in 2011 through 13. They had to settle for a multi-million-dollar settlement and a judgment. It was an enforcement action. So we went into this thinking we have our hands full. Not only do we have another FCPA issue, we also had a revenue recognition issue and a potential accounting fraud issue. Of course, counter that with, while we're doing our investigation, we learned of another issue in China, which we had a self-report. So it really was a perfect storm for us. And frankly, at some points, we thought there'd be a major enforcement action, either by the SEC, who was conducting the investigation pursuant to subpoena power, or by the Department of Justice, who we also had a self-report the China matter to. But through our investigation and cooperating with the SEC and DOJ, at the end of the day, which was last week, they decided not to issue an enforcement action and frankly drop the investigation. Now, part of that was they appreciated the investigative work we did, and we were handing over documents, handing over materials, handing over interview notes of employees we were speaking to around the world. But another very important aspect of how we handled that investigation was this company had employees in China. And the SEC can just serve a subpoena on the company here in the U.S. and ask for those employees to be brought over. Their authority is that broad based on the subpoenas they can issue. But what we did is we reached out to the enforcement attorneys and said, listen, we've been interviewing these employees. If you would like to speak with them, we'll set that up. And we put together some conference calls. They interviewed the employees from the U.S. while the employees were in China with interpreters. And they appreciated that so much, it really built up a lot of goodwill. So we got a great result for the client. But that's just one example, one small sliver from one agency on how they really are able to assert their authority all over the world, so that during this investigation, I am making available employees of this major U.S. company available for interviews with the U.S. government, and they're either Chinese citizens, German citizens, maybe they could be Russian citizens. Of course, what I have seen most recently, and we should put it in the PowerPoint for next year, is there have, we can have a lot for next year, there have been laws attempted to be passed, or even I think close to being passed, in Russia and China, which make it a criminal offense for their citizens to cooperate in a U.S.-based investigation. So if the SEC or DOJ or another agency want to interview an employee, or even if they send me to do the interview and I am cooperating on behalf of the company with the agency, it could be a violation of Chinese or Russian law for that employee to knowingly and willingly cooperate. So that's troublesome, but I think it somewhat is a product of our time. There is some pushback, I think, by these countries who are seeing this massive FCPA focus from the federal government and the SEC, and a lot of people are being interviewed at these companies, and I think they want to get a better handle on that and control it. So now I'm going to get into the, how are we doing for time? So as I basically explained this, U.S. laws can be enforced against foreign entities and individuals, even if the activity is outside the U.S. There is a 2018 Second Circuit case that did limit this a bit in the FCPA world. And in that case, there was, the DOJ went after a foreign citizen who had no ties to the U.S., who had been accused of bribing somebody, a public official in an Asian country, for a contract that had nothing to do with the U.S. at all. It didn't touch a U.S. company, but this individual who was charged at some time and previously had been an agent for a U.S. company on another matter. Well, the federal government charged him criminally, and the Second Circuit pushed back on some of the charges that were dismissed, and they placed some limits on the extraterritorial liability, agency liability for folks in that position. However, I think the caveat is the Second Circuit disagreed with the charging decision, and if they had charged him with just straight conspiracy, I think they would have had a better jurisdictional argument. But you are starting to see this. This was 2018. The courts are pushing back a bit on this expanded extraterritorial power of the SEC and DOJ.
Hey, Rob, let me jump in for 1 second, just remind people, too, this isn't always necessarily in the regulatory and criminal area as well. A lot of you may have followed the relatively recent Madoff decision out of the Second Circuit, the Koch decision, which held that U.S. bankruptcy laws can have extraterritorial application. And in that case, it was a situation where a U.K. fund had invested into a BVI fund, and then the BVI fund invested into Madoff. And the clawback action traditionally would have been from the U.S. to the BVI fund, because it was a direct investor into Madoff. But the Second Circuit allowed Picard to go and actually try to claw back directly from the UK fund. And if you think about it, it's a pretty brazen way to look at the world, right? I'm a fund manager in the United Kingdom. I made an investment into a British Virgin Islands hedge fund, and now I have an American bankruptcy trustee suing me in the UK. So it's not just in the criminal space. This is becoming more and more of an issue in some of the civil areas as well, especially in the bankruptcy world.
Yeah, and I'll jump ahead just to expound on that. I'll jump ahead a bit. I was going to cover this at the end, but what you see in the criminal side is it's sort of like a hub and spoke conspiracy. And what happens, you have the HUD, and this comes from when the racketeering laws were passed to fight against organized crime in the U.S. What they were doing is going after the enterprise, which is the corrupt organization, but also the individuals that feed into that. So they're the spokes. The hub is the enterprise, and the enterprise may be involved in many different types of criminal activity. When that law was formed, it was organized crime, so it was drug dealing, bookmaking, homicide potentially. So anything that would be reasonably foreseeable for that enterprise, if you had joined that conspiracy as, say, the drug dealer or the bookmaker, as long as it's reasonably foreseeable to you that somebody is out murdering people, that somebody else is bookmaking, that somebody else is a drug dealer, you can be held responsible for their actions if you are part of the enterprise. And a lot of people misunderstand that that's part of the RICO laws. They're very broad. They're used consistently by the federal government to reach potentially foreigners who join an enterprise. And they may be joining it as part of a bookmaking operation. In fact, I can speak a little bit later about an offshore bookmaking case we did when I was with DOJ, and we indicted multiple people in Antigua, some who are still fugitives. But the people here, we were able to place under arrest in Antigua. Antigua did not extradite, at least 2 people that are still there. But they had joined this bookmaking conspiracy, and when we tried them, multiple defendants, some of them had never met each other. They didn't even know, they're sitting in a courtroom on trial in a RICO conspiracy for this large bookmaking operation that touched all parts of the world, and yet they're sitting next to a co-defendant who they have no idea who he is or what he did. But as long as what he did was reasonably foreseeable to the enterprise, that will help motivate what your sentence is. You will be responsible for his conduct. It's like a moving train. Once you're on, you're responsible for all the baggage on it. So that's important to keep in mind. And I think if you do get involved in the Caledonia case I'll speak of shortly, if you do get involved in a conspiracy and it gets taken down, you may not only be responsible for what you did, but also the actions of others. And that can also affect you. I know there's a forfeiture attorney from DOJ here, but it can also affect you in the forfeiture realm. And in fact, that Antiguan case, we got a $25 million forfeiture judgment against the entire enterprise, which was many individuals. However, the only people that are responsible for paying that $25 million judgment right now were the people that were on trial in the courtroom, one of which who was a very low-level money courier. So he now is paying back $1,000 a month for the rest of his life until that $25 million is paid off, because it's joint and several. While the ringleader is still in Antigua right now, still probably running an offshore book. I just want to go through some relevant government and private agencies. First one is Department of Justice. That's where I worked for almost 10 years. Securities and Exchange Commission. I'm sure people are well aware of them. I spoke about them a bit earlier. I'm doing a lot of SEC work currently. They're frankly getting very aggressive in many different spaces. Department of Treasury, they take a leading role in, they review SARs, which are suspicious activity reports, and CTRs, which they track a lot of the money movement in and out of the U.S. and even within the U.S. And they work very closely with the Department of Justice and the FBI to look for folks that are either laundering money or violating the Bank Secrecy Act.
Yeah, and Rob, to jump in there, this again applies to on the civil side. The Department of Treasury is particularly difficult when it comes to organizations that are on their list. And we've had many clients who have found themselves either on the list and when they shouldn't have been, or have names that are very similar to companies and individuals who are on that list. And it is not an easy task to get off that list. And one of the reasons are that New York banks will broadly enforce the lists that the Treasury puts out there. And so even if the U.S. Treasury says at some point it's okay, you have to get that clearing bank in New York to agree that they're going to release that transaction. And this happens. I had one where it involved completely foreign contracts. Contract between a Russian organization and an Indian organization, and yet the money was tied up in a clearing bank in New York because it was a dollar-denominated transaction, and the clearing bank believed that the entity's name was on the IRS list. It wasn't. It was just similar. But it's a problem, and it's an example of where Treasury plays a role, again, not even necessarily in the criminal realm, is actually getting actively involved in transactions between contractual agreements between private foreign companies.
Yeah, they have a massive amount of information. They get daily reporting from banks and other individuals who receive money, and they have to file suspicious activity reports with Treasury if they see something that may be unusual. And Treasury won't necessarily act on all this information, but they store it, they have it. So when something pops up, maybe a name from the FBI, they have this vast warehouse of information they can look at, and they can see all the transactions that somebody may have been involved in. Lastly, I want to talk about the Financial Industry Regulatory Authority. I worked there for, after I left DOJ, I was senior litigation counsel. Now, FINRA is a self-regulatory organization. They're overseen by the SEC. But they're technically a private company. They regulate all broker-dealer activity in the U.S. or any broker-dealers that are anywhere else in the world if they're a member of FINRA. FINRA does have, it's not really called a subpoena, but they have 8210 authority. So they'll send individuals 8210 requests for information. If you're a member of FINRA, this 8210 is much more powerful than even a DOJ subpoena. They can get access to your private emails, your work emails. They can drag you in for a deposition when you're under oath and ask you pretty much anything. And so if you have any clients out there that get an 8210 letter, you're going to want to contact somebody like me who worked at DOJ and FINRA and understands the agency. Because the other interesting thing about those requests, you can ignore them if you're not a member of FINRA. They don't have authority over anybody outside of FINRA. Now, what they will do in that case, they will then reach out to the SEC and DOJ to try to get assistance. Now that was very disconcerting to me when I joined FINRA. I came from DOJ where I could issue subpoenas really at any time of the day, whenever I wanted to drag people in. The FBI would serve those subpoenas. To go to FINRA, where I would be building cases against a broker-dealer, and yet if I needed, say, the victim of the fraud or the buyer of the security, if those individual or any individual is not a member of FINRA, I cannot get them to testify at my hearing. So your job is very difficult. However, the 8210 letters are powerful if you are sending them to somebody who is a member of FINRA. So that's an important distinction. And in FINRA, a lot of people also don't understand this. I didn't know it before I joined. They have an office it's called OFDMI, the Office of Fraud Detection and Market Intelligence. They essentially are the folks that track every trade in the US and in other parts of the world also, and they feed that information to the SEC. So they, I think last year, sent 850 referrals for potential fraud or criminal cases to the SEC and DOJ. And I know from working there, they sent out a lot more letters, just informational letters to the SEC and DOJ concerning potential troublesome trades that they track. So I'll briefly talk about this SEC versus Caledonian case. At the time, this was essentially, I'm not going to, there's a lot of words on these slides, but essentially, well, like one of yours, so I feel like I'm part of the club now.
Yes, you can skip right.
That's right. But essentially, this is a pump and dump scheme. It was fraudulent transfers of fraudulent stocks and securities. The victims were folks that were, after the pump and dump, they lost their shirt. The SEC stepped in. They did take, there was an enforcement action against Caledonia, which is the bank in the Cayman Islands. The bank filed bankruptcy. There was a temporary restraining order. So the SEC wins at the end of the day, presumably, but because they were bankrupt, they never paid, I believe it was a $25 million settlement and judgment. There was no money left to be paid to the government. Now, John had asked me to look at this for this presentation, mainly because I think at the time some people thought that, or didn't understand why the SEC would have jurisdiction over this since the bank was in the Cayman Islands. But as 15 USCA 77B states pretty clearly, they can file enforcement actions against foreign entities if it involves conduct within the U.S. or conduct occurring outside the U.S. that, again, here's that foreseeable term again that I brought up earlier that's important in the RICO world, if it has a foreseeable substantial effect within the U.S. So it's really, I don't really think it was a close question. They clearly had jurisdiction and were in their rights to bring this enforcement action. My biggest question about this case, and I told John this yesterday, I don't know why the DOJ didn't indict people here. They clearly had jurisdiction too, and in fact, much more jurisdiction than the SEC, and they can extradite people, or at least attempt to, which the SEC is not going to be able to. So how U.S. regulators find jurisdiction to investigate offshore activity. What is very hot right now are cryptocurrency blockchain companies abroad. In fact, I represent two of them currently. One is based in Estonia. They received an SEC subpoena. Of course, it was served upon their one U.S. employee that they hired. They, of course, terminated him a couple of weeks before they received the subpoena. But it still doesn't matter. The SEC now has jurisdiction because they were allowing investors from the U.S. to participate in cryptocurrency token pools run on a blockchain in Estonia. So, of course, the Estonian client calls me very surprised why they have to cooperate with the SEC, but the SEC can bring an enforcement action against the company because of the cryptocurrency they allowed to be sold from their platform in the United States. Now, of course, one issue the SEC have is now because of the GDPR, which is a big privacy law that passed in Europe, I'm sure many people are familiar with it, I'm not able to produce a lot of the documents the SEC needs. So they are going to have to go through official channels in Estonia using an MLAT to try to get this material officially. That makes their life a lot more difficult. And frankly, it prohibits me from cooperating proactively on behalf of the company, which paid such dividends for the case that I just closed last week. And I think I could probably get closed for this company, but we're running into that snafu, whereas if they produce the information requested by the SEC, they'll be breaking law in Europe and Estonia. Okay, so one thing I don't want to run out of time without speaking about, I already spoke about FINRA letters, but SEC and DOJ subpoenas. One of the biggest surprises for me now that I'm in the private sector is the absolute horror that clients go through when they call me after they've received a subpoena from the SEC or the Department of Justice. And I think what scares them, among other things, is usually the deadline. You get a subpoena served either in the mail or by an agent from some federal alphabet soup agency, and it usually says produce a laundry list of items by this date. And a lot of people don't understand that date is usually just chosen by the agent or the AUSA, the prosecutor, and if you don't produce it by then, they could run into court and have you held in contempt by a judge for not abiding by the subpoena, but that's extremely rare. Usually what you want to do if you get a subpoena by one of these agencies is get an attorney who truly understands those agencies, and the agencies know that attorney so that they can start negotiating on your behalf. Number one, to move the date, and that's pretty easy to do. I know that it's probably a secret among the defense bar. I haven't been doing it that long, but clients will say, please do anything you can to move this date because either I'm not available, we'll never have the documents by then. That's a pretty easy thing to do. You call the prosecutor, you call the enforcement attorney, they'll bump the date out for you, and then it turns into what I call a rolling production. And I used to allow defense attorneys to do this all the time. Most AUSAs do, and then over the course of sometimes a very long period of time, you are rolling that production out to the enforcement agency. Now, another important thing when you're dealing with DOJ is you want to know why you're a focus of this subpoena. And what's important for attorneys who do this work to do is ask the attorney for the government, what role is my client playing here? Are they a witness? Are they a subject? Or are they a target? You don't want to be a target. That's bad. And you may, at that point, you may not actually want to be producing materials. You probably want to take 5. But most people are in this gray area, which is called a subject. And at that point, you have to make a decision based upon communications your attorney has with the government or the SEC, what role you're going to play. You're going to be cooperative and help them with their investigation, and hopefully they allow your attorney to do an internal investigation, particularly if it's a company, and then report the findings to the agency. That is usually, not always, but usually the best course of conduct. That's why I've been very successful in getting companies out of trouble or out of the bullseye of the government by doing that myself, and then you report your findings. And what you don't have are government attorneys and SEC enforcement attorneys deposing your client's employees, putting them under oath, and picking through all the documents themselves. Instead, the white-collar defense attorney gets to do it if they're trusted enough by the agency, and they report their findings. So that is a very important distinction. It's important if you ever do get a subpoena by any of the agencies that you get a clear understanding of what your role is. If you're a subject or a witness, witness is the best to be. That just means they need something from you. They want you to testify to lock in your testimony, and it's going to be used against somebody else in the future. Subject is a bit more tenuous, but frankly, it's a big bucket. And if you get an attorney who understands what the investigators are doing, they'll probably be able to give you a good bill of health and say you're not going to be a target. But then you have clients, and frankly, we have some now, who the prosecutor will say, or the enforcement attorney, yeah, they're a subject, but leaning towards target, depending on how this goes. So that's when you have to be extremely careful, but also proactive in dealing with the government. What you don't want to happen, from my point of view, is not aggressively pursue what you need to get for the government before that client is potentially raided by the FBI with a search warrant. That is bad. That's never happened to me, but I have heard from other folks in the white-collar space that is the call you don't want to get when they've called you and you're negotiating with DOJ to turn documents over materials or maybe present somebody for a proffer session, and at 6 in the morning the FBI just kicked their doors in and took all their servers. That is bad news. So you want to control for that.
So We wanted to leave a little bit of time for questions. We can certainly cover more material, but sometimes it's interesting to see what's on people's mind in the room and what they want to know. So before I take over again, do we have questions for either Rob or myself about either the application of judgment, executing foreign judgments, or on the criminal side? I see one in the back.
Yeah, this is really pre-judgment. A Floridian lawyer, sadly now dead, told me many years ago that it was easier to enforce an English judgment in the courts of California than it was one obtained from Florida. I wondered whether there is still the same appetite for great British justice. As you know, we have a long-arm jurisdictional reach of our own, of which we're very proud, and wonderful freezing orders, worldwide freezing orders that we grant almost to a penny nowadays. What are the evidential requirements you have across the states, both here, for example, and in New York and in California, for the purpose of enforcing freezing orders, and what sort of criteria would you apply for that purpose? And can we ever get costs from an American defendant? That might be more controversial.
So freezing orders are a whole different kettle of fish, as some people like to say, because you're not necessarily dealing with a judgment in a lot of cases. So let me answer that in three pieces. The first piece is the enforcement of UK judgments. I've enforced many UK judgments in different states in the US, and it's typically very, very simple. There's usually not any issue about the UK legal system, fraud, or due process or anything else. Worldwide freezing orders are a little bit harder, but we have been able to enforce them in a number of states in the US. The issue there comes down to whether it typically comes down to the jurisdictional issues we were talking about earlier, right? It's not the entry of the order by the UK judge or the due process requirements. It's much more related to where did this freezing order enter, and how does it have application against either individuals who weren't personally before the court, or assets. So, prime example. Yes, the UK does issue worldwide freezing orders, but other Commonwealth jurisdictions do the same thing. If you've got a worldwide freezing order against somebody you don't have a final judgment against, who arguably wasn't subject to jurisdiction or wasn't personally served, then there's a fight about that. But as a practical matter, our experience has been you can enforce them. The issue there sometimes comes down to what assets and where are they and what are we looking to do. If it's simply a New York clearing bank, it's a much easier road than if we're talking about, actual hard assets somewhere, a piece of real estate in Wyoming, or something like that. So I know that's not an answer to the question, because it depends, but as a practical matter, typically, as long as you have the UK courts entering a valid order, we can get a US judge to take a pretty good look at it and get it enforced. But there are exceptions, as there are in every case. Does that even come close to making sense?
No, it does. No, thank you very much. I'm a very strong Anglo-Saxon perspectives in relation to this.
Yeah, where we've had a harder time in the US, bluntly, is not the UK. But there are other, obviously, Commonwealth-like jurisdictions in Asia and other places where, for example, there might be a little bit more corruption, even if it's not in the legal system, where I think a US judge will take a look. Also, remember, we talked about this earlier, in a lot of these cases, you're dealing with state court judges applying state law in places where they don't usually see this type of activity. New York is an exception, but if you're going to, North Dakota, because somebody has the rights to some kind of fracking oil well, then you're dealing with a judge that maybe has never seen one of these and might have a natural skepticism, maybe not about the UK, but maybe about Singapore, or maybe about Hong Kong. So even in other countries where they've got a Commonwealth legal tradition, sometimes you can get a US judge that'll look askance at some of the claims or some of the orders that issue.
We just need as many friends as possible after Brexit. So that's a key part of our thinking.
The world, after Brexit, it'll all be good. It's all going to work out. Other questions? In the back right there, I guess. Start.
I have a post-judgment discovery question. If you have, let's say, a UK judgment and you're trying to take post-judgment discovery of a U.S. company, and you can't use 1782, but you believe the U.S. company may be owned in part by the European citizen, how could you take post-judgment discovery if no state in the U.S. has personal jurisdiction over the European judgment debtor?
So there's a couple of pieces to that. Let's take 1782 out of the mix for a minute. In the U.S., typically, we talk about how broad U.S. civil discovery rules and laws are. But the little dirty secret is it's very difficult, even in the U.S., to get any type of asset discovery while a case is ongoing. But once you have a judgment, in most states, you are entitled to post-judgment discovery, which includes assets. The way you would probably do it in your instance is you would probably, if you have your judgment, you would probably need to take it to any state, have it enforced, go to New York, make the argument that it is likely that at some point assets are going to come through New York. So get a New York state court judgment, and then take post-judgment discovery on the New York judgment you just obtained. That's the process you would probably go through. When I mentioned 1782 before, it was in a little bit of a different context. So for those of you who don't know, 1782 allows you to take discovery in the United States in aid of foreign proceedings. It's not usually a tool for asset discovery because in most states, and even in the federal system, you're not allowed asset discovery while the case is pending. But in theory, if you have a judgment, you could make the argument under 1782 that I need this discovery in aid of the foreign proceedings because I need to know where the assets are. And that is not a 100% proposition. That's a little bit of I'd say that's a 50-50 whether a court might give you that type of relief. And the problem there is 1782 is a federal statute, whereas most of this post-asset discovery we're talking about are state court issues. But if you have a judgment, all you have to do is get it enforced in the U.S., and then you can use the post-judgment discovery rules in the state where it's enforced. In New York is the easiest because if someone's going to do a dollar-denominated transaction, you could, with a straight face, make the argument that an asset is likely to pass through New York. There's another question up here.
Thanks so much. In terms of the state statutory overlay, as well as sort of the issues that you highlighted, John, about the sort of state judges and the potential issues there, particularly some jurisdictions outside the sort of larger ones, are any of these actions either fileable or removable to federal court under the International Diversity Statute and Standards?
Yeah, you can. This is where things get a little bit sticky again. So you can remove some of these cases. I won't go through the entire removal jurisdiction. So what we're talking about is, for those who don't know, there are really two separate court systems in the U.S. There's the state court system, there's the federal court system. So if you think about a state like New York, you've got New York state courts, you have federal courts that are in New York. The issue that comes up is, and the question becomes removal jurisdiction, typically if you have a citizen of a foreign country and a U.S. resident, you can remove to federal court. You have what we call diversity jurisdiction. If you have complete diversity on both sides of the V, meaning people from different states on both sides of the V, you can remove it. The problem with that is, even if you get into federal court, you're still applying the state law, the state's law in that space. You're not applying federal law to enforce a foreign judgment. Now, you can argue that in some cases it might be nice to have a federal judgment because it's enforceable in different ways. But to be blunt, I have often found that in these types of situations, you think about maybe state court judges being a little bit slower to go along, but sometimes it can move quicker in state court, believe it or not. The dirty secret in the U.S. is, while the federal courts are very good, and while many state courts are very good, the state courts typically are better places to go if you want very quick, very swift sort of action on something that you need either a preliminary order on or a quick judgment. Because a federal judge is much more likely to hem and haw and think it through and get 17 law clerks involved and hold a hearing and maybe have an evidentiary hearing. And a state court judge might just look at it and say, done. So There is the bias has typically been, oh, go to federal court because the judges are better, but that's not always the case. And in states like New York or in Massachusetts or other places where you've got an appointed state court judiciary that's non-political, they're not running for office. I mean, some states in the U.S. judges actually run for their judgeship. So they're taking political donations. They're putting their views out there. In New York, you're not dealing with that. So I have no problem, and in fact, I have found it pretty quick to go into New York State Court. Because the other reason is, if you can find your way into federal court, you have to file an actual lawsuit. Whereas in New York State Court, you can file this summary judgment procedure, which moves things very quickly. So you got to think through, yes, which set of judges might I want, but more importantly, once I get in that court, how quick until I get my judgment? Because, it's not a secret. If you're trying to enforce a judgment against someone in the U.S. and they have assets here, they might try to move them while you're going through this process. So you might need an injunction at some point. And you can later claim that it was a fraudulent transaction when they moved the assets, but then you got to chase the person and the assets all over again. So I think you want to think through, what's the speed element going to look like? Where can I get an injunction if I need it? Where am I most likely to get post-asset discovery? Those types of issues.
Excellent, thanks.
Okay. Other questions? Over here.
I was a little intrigued by your statement that you could enforce a judgment in New York simply because monies could flow through correspondent accounts. Practically speaking, how does that work? I mean, what do? Well, there's two sides to this. Obviously, the judgment debtor knows you've enforced the judgment in New York, right? Because they've been served. And secondly, then what do you do? Try to figure out where he banks in the other country and basically put each of the financial institutions, because it could be several correspondent accounts, so not all in the same place necessarily. And how would they stop the money? And then I think the further on from that is, okay, as a business, I'm going to stop doing in dollars. I'm going to make all the contracts pound sterling, euros, and I have to worry about it.
So, first of all, don't ever let the practical get in the way of a good legal theory. So that's a couple of things. When you have a judgment in the U.S., once you have the judgment, so let's go through the process, right? We've got our foreign judgment. We brought it to New York. We've enforced it. We've got a New York judgment issued by a New York court. At that point, you can get. I'll call them for my British colleagues in the audience. I'll call them freezing orders. You can get an order that you can then serve, saying to a bank, essentially you are enjoined from paying out money that comes into the account of somebody. And you're absolutely right. It's a little bit dicey. You'd have to get a court to agree that, look, these 4 or 5 banks are likely to have money that's going to flow through them from this individual, this company, and they're going to freeze it. Once those are served, that's exactly what will happen. When that bank receives a wire, or however it's going to get it, with a dollar denomination for the X company that's got the judgment against it, it will seize it. And then you can go to the court and you can get the court to release those funds to you. It's not easy. I don't want to pretend it's easy. It's a way to get there. The other thing to think about, and you raise it, it's a very good point, is, okay, can we just go to euros? Can we just do can we start using the yuan? Can we do cryptocurrency? Of course you can. But as many of you know, it's very difficult in some industries to do non-dollar denominated transactions. And in some industries, you have to do it in dollar denominations. It's also, even if you are doing transactions in foreign currency, personally, my personal experience has been it's very hard to find a global company or an incredibly wealthy individual that can manage to have absolutely zero contact with the United States. Whether they show up in person, whether they own assets, whether they move money through it, it's possible. And if you have someone like that, then this whole process doesn't make sense. You probably wouldn't bother. Any other questions?
Can
Sure. All right, we are 5 minutes. Thanks, guys. We will stick around for a few minutes. Lunch is in 4 minutes, so have a great lunch, folks, and great rest of your day. Thank you.